I'm Alex Witkowski. I'm a patent attorney here to talk about patents focused on early stage companies, but a lot of it applies to larger companies as well. I have a background in electrical engineering, spent 6 years at Intel in microprocessor development, and then I transferred into Intel's legal department, and they sponsored me to go to law school and prosecute patent applications for them for 5 years. Then after graduating, I went on my own. I also did an MBA program at Columbia Business School and London Business School. So I have and have been licensed as an attorney since 2000. Patents involve not just technology, but law and business strategy. So I think I have a strong background in all of those to see how they play together to help companies develop a patent portfolio that means something to them and their business. Just the general disclaimer, a lot of this information I'm giving is legal information, it's not legal advice. The law is complicated, and sometimes there are exceptions to rules. I can't boil all of law into a PowerPoint slide. So this is meant to give you some framework to think about things, but in your specific situation, it may invoke an exception or some kind of caveat that I didn't mention. So always keep that in mind, that you don't want to rely on any of this without actually checking with a patent attorney about your specific situation. And that's basically the difference between legal information and legal advice. There are lots of different types of intellectual property. There's utility patents, which I'm going to focus on today. There's design patents. Some of you are mentioning industrial designs. Design patents are generally focused on that. It's the aesthetic look and shape of the device that's separate from its utility. And that, of course, can be patented. Apple does that all the time. And there's trade secrets. Sometimes there's a decision between filing a patent and using it as a keeping it as a trade secret. The risk with a trade secret is that if someone independently develops the idea, you don't have any recourse. It really only protects you against someone stealing an employee taking it from your files, etc. So there's very limited protection, and that employee may be judgment-proof. There's limited things that you can do with trade secrets. But of course, if you've got an idea that people were not going to be able to figure out, a semiconductor process deep within your manufacturing that you don't think anybody's going to be able to see when you sell it, that may be worth keeping. Sometimes it changes so quickly you couldn't even patent it. The technology is moving constantly, so a patent may not make sense. So that's something to consider. Copyright protects things like books. It also protects software, but it's very different than a patent in that it really protects someone from copying the source code, not the idea. So somebody, if you had a copyright but not a patent, they could generally make the same product by independently writing the code. So it's useful in some cases, but not as powerful as a patent. Trademarks protect, brands. It's really about protecting the consumer from confusion. So, McDonald's, if you come up with a similar name that confuses the public as to source, or a similar logo that confuses the public as to source, then there could be trademark infringement. Trade dress can be something like the look of a restaurant. That it actually, you try and copy the look and feel of a restaurant. It's similar to trademark in that it's kind of being associated with a particular company, and you're trying to trade on their goodwill. And then finally, plant patents, probably something nobody here is interested in, but maybe Monsanto. But we'll skip that. In case some of you haven't seen the patent or looked at them, this gives you a little bit of an idea of what they look like. This is the cover page of a patent. Generally, you have a selected photo, a selected image that's kind of representative of the set of photo images. You've got the title, seawater desalination system, the inventors, the assignee. You've got the date it was filed, and here is the date it was issued, the patent number. And this is an abstract. This is a good way to get a quick idea of what that patent is about. And a lot of people look at this and the text and the figures, and they say, oh, this is overly broad, they shouldn't have issued the patent. But what really defines the patent in the scope is the claims, which are towards the end of the patent, and it's not, this can be recognized by someone who's an engineer. They can see this is a diagram, maybe not a circuit diagram, but, and the technical document, even though there's a lot of legalese in a patent technical document, a technical person can recognize what it is. Claims are very hard, Claims are kind of unfamiliar territory for a lot of people that haven't looked at it. But what that really is it defines the boundaries of what is owned by the person who received the patent. Sort of like the boundaries of a piece of real estate, where you say, you step over this line, you're on my property, and you've got to go. The same thing here. This is defining what is owned by the person, this patent issued by the person who received this patent. And the beginning part doesn't change from the time the patent was filed. The disclosure is what you knew as of a certain date, but the claims do change. They're negotiated back and forth with the patent office. The patent office says, the claims as you have them, you're trying to claim too much. There's this prior art that covers the same thing, and part of the negotiation process with the patent office, you're saying, okay, we'll change the scope of this claim by adding these terms, or you're arguing you don't really understand that reference you cited correctly, it's not the same thing, it's different for this reason, et cetera, et cetera. And so these can change. This is only part of this particular claim. It goes on, but I just wanted to put the beginning part to give you a sense of what it looks like. And this is saying a seawater desalination system comprising, and then it's listing elements. So a membrane filtering pump, which outputs seawater stored in water-obtaining vessel in accordance with the first control signal. And there's a lot of detail. And so when you look to see whether this someone infringes this patent, they have to have all of these elements. Otherwise, they don't infringe. And so this is very critical to the value of the patent. If you include extra words in there, and let's say they don't have a membrane filtering pump, they have everything else, but they don't have a membrane filtering pump, they're not going to infringe because your patent is narrower than what they're doing. And so that's why this argument is with the patent office is very important. These words matter, and that's why a lot of inventors, they don't want to look at the claims because they're not very familiar with the claims, so they check the text, but they don't look at the claims, but the claims are the most important part. So you really, if you're reviewing a patent, you want to force yourself to make sure that this makes sense and there's no extraneous details in the claims that are going to make your patent invaluable. And sometimes, when you file an application with a patent attorney, they're going to want to get you something, an issued patent. But sometimes the claims have gotten to the point where the patent's not worth anything. You might as well give up because, either you want the patent for ego or you want it to be able to add a little uncertainty for competitors. That's fine if you want that. But if you want commercial value from the patent, there's a point where you say, there's too many elements. They can easily design around this. Maybe we should just abandon it because I'm sinking money into this and they found prior art that's killing it. So you want to pay attention to that too while you're prosecuting the application.